The SQE curriculum requires that you understand the differences between joint tenants and tenants in common, and this distinction also both in law and in equity. So we're going to deal with that now. So what's a joint tenancy? A joint tenancy is a type of joint ownership of a property where each owner is called a joint tenant and each owns the whole of the asset rather than a distinct fractional share. This means that a joint tenant cannot point to a particular share or interest in the property, as his interest is in the whole of the item. When a joint tenant dies, the property passes to his personal representative as part of his estate. This is known as the right of survivorship. Now, what about a tenancy in common? A tenancy in common is a type of joint ownership of a property where each owner owns a separate share in the property. Each owner is regarded as having a distinct share in the land, even though the land in question has not been physically divided up between the owners. Upon the death of one of the tenants in common, his share passes to his beneficiaries in accordance with his will or intestacy, as opposed to passing automatically to his wife, let's say in this example. So let's take an ordinary situation and a simple example. Josie is married to James. They own the freehold to their house. Both Josie and James's names are on the title deeds. This is a joint tenancy. If Josie dies, then her notional share in the property will pass automatically to James. This is the idea of survivorship. If Josie does not want this to happen, then they can enter a declaration of trust to separate their shares so that they become tenants in common. Then her share would go to whoever is in her will. Let's say if she wanted all of her property to go to her best friend who looked after her when she was very ill. So let's return to our earlier example to illustrate the two kinds of co-ownership. Bill has two daughters by his first marriage, Janet and Kim. Bill has remarried and added his new wife's name, Susan, on the title deeds to the property. And the property is a country mansion in Hertfordshire, so that both Bill's and Susan's names are registered on the title deeds. Bill is now considering how his daughter's positions could be protected upon his death. Susan has her own children. She also wants to protect her own children's interests. They agreed to hold the property as so-called tenants in common. So a tenancy in common is different from a joint tenancy, as we've just seen. A tenancy in common treats the property as though the co-owners have two distinct shares in the property. This separation in equity allows the tenants to deal with their shares of the property separately. This is advantageous if they decide to create separate wills with different beneficiaries. So, if the property were to remain a joint tenancy, then if Bill were to die, then the whole of the beneficial interest would pass to Susan. By contrast, under a tenancy in common, each have a distinct share. If Bill were to die, then Susan would retain only her share upon Bill's death. Bill's beneficial interest would pass into his estate. So Bill's share would not pass to Susan automatically, rather it would go into his estate and be distributed in accordance with his will, if he had one, and to his two children, Janet and Kim, if that was the effect of the will. If he were not to have created a tenancy in common using the correct formalities, then the whole of the beneficial entitlement to the property would have passed to Susan. Now, Bill's beneficial interest in the property is a type of right that can exist only in equity. In other words, it is not registered at the land registry, and it can only be recognised in a court of law. So, what does this example show? There's a difference between legal title and beneficial interest. Where this is the case, the starting point is that both co-owners own the property jointly. Two or more people may buy property together. If they do so and their names are both recorded on the title deeds, then they are legal co-owners and so-called joint tenants, just like Bill and Susan. The default position in terms of their beneficial ownership is then that they are each entitled to the whole property. This means that if one joint tenant were to die, then the other joint tenant's interest would automatically pass to their co-owner rather than going into the deceased's estate. This is the notion of survivorship, whereby one person's beneficial interest automatically passes to their co-owner upon their death under a joint tenancy. However, legal and beneficial ownership can be separated and defined using an agreement or declaration of trust, and if done by agreement, the co-owners would be electing to own the property as tenants in common, where each owns a specified share of the property. And this means that if one co-owner were to die, then the other co-owner would not automatically inherit their share. Rather, their distinct share would travel with the deceased co-owner's estate. Now, there are various circumstances in which it can be said that a tenancy in common can arise as opposed to a joint tenancy. And these are, firstly, where there's an express agreement dividing up the shares in the property, or one of the so-called unities is not present. So this comes from the House of Lords case of AG Securities and Fornan. In this case, it was said, in my opinion, there cannot be a joint tenancy where there are serious doubts about each of the four unities. These so-called unities are time, possession, interest, and title. So if one of these is in serious doubt, then there will be a tenancy in common rather than a joint tenancy. In other words, the interests of the co-owners will be severed and treated separately. So we'll start with the unity of time. This means that the interests of all the co-owners must arise at the same time. In other words, they take up a lease or purchase their home at the same time. The next is the unity of possession, and this means that each co-owner must have an equal right to occupy or possess the entire property, as opposed to a co-owner being excluded from a part of the property. And the next is the unity of interest. This means that the interest of each co-owner must be identical in nature, duration, and extent. For example, a joint tenancy could not exist between a freeholder and a leaseholder. Because joint tenants have unity of interest, any dealing with the land generally requires both of the joint tenants to participate in a transaction, like when the freehold or leasehold is sold. And the next is the unity of title. This means that the interests of the co-owners must arise from the same document, like the title deeds. So if any one of these unities is not present, then that is an indicator that the co-ownership is by way of a tenancy in common rather than a joint tenancy. Now, the next way that a tenancy in common can arise as opposed to a joint tenancy is if there is severance. So, for example, there may be a will stating, in the event of my death, I grant my share to my children to be divided equally between them. And the next way that a tenancy in common can arise, as opposed to a joint tenancy, is that if there's other evidence showing that the parties intended their beneficial interests to be different from their legal interests. The leading authority on this is the 2007 Supreme Court case of Stack and Dowden. So this stated that the burden will therefore be on the person seeking to show the parties did intend their beneficial interests to be different from their legal interests, and in what way. What this case shows is the post-conveyancing financial management, such as payment of mortgage or payment of household bills, may well indicate that the parties intend to have the beneficial interest divided up different from their legal interests. And this must be demonstrated on the facts. Many more factors than financial contributions may be relevant to assessing this, and unequal contributions to the purchase price may also be relevant. So let's consider a question of the kinds that you could get in the SQE exam on this subject. Two forms of co-ownership are recognised in landlord, the joint tenancy and the tenancy in common. Which of the following statements about them is correct? For a joint tenancy to exist, there need only be unity of possession. For a tenancy in common to exist, all four unities must be present. For a joint tenancy to exist, there need only be unity of interest, title and time. There cannot be a joint tenancy where there are serious doubts about each of the four unities. The four unities no longer apply in the co-ownership context. The correct answer is D. There cannot be a joint tenancy where there are serious doubts about each of the four unities.